Kolsrud. Thank you so much, Josh, for joining us today on the show. The timeline, I think this is where the defense may have an opportunity to really, and Michael and I have been talking about this, really hone in, because she discloses this to her parents, and then it's 3 or 4 years ago that she says, oh, I heard about him on the news, then I went to law enforcement. How do you attack that as a defense attorney and credibility of this particular witness?
Sure thing. So when I was a prosecutor, one of the things that I taught my younger prosecutors was that disclosure by a victim is one of the most important events in any sex crimes case. And here you have a period of time where the victim initially disclosed to her mother and then waited 14 long years before going to law enforcement. And to a defense attorney, that's huge, because what they want to do is attack her credibility. They want to say that her testimony is, tailored to what the charges are, to what she's already read about the 2008 case, from what the defendant was initially fleeing the country from. So it does give them an opportunity, but it also helps the prosecutor because it helps the victim's credibility by proxy, right? It's saying that here's the reason why she didn't initially come forward to the police. And that is because even her family didn't believe her, and they discouraged her really from coming forward. So it gives the jury the why, and it corroborates what the victim is testifying to, which is, I really did disclose right after this happened, and just that nobody believed me.
Yeah, it's a little bit sad in that, she testified earlier about the fact that she had this conversation with her mom, and her parents didn't take any action. I guess she didn't feel supported, so she decided not to move forward. I would imagine that's a very difficult thing for a daughter, but I wanted to ask you this as a former prosecutor. Utah is one of 29 states that right now in 2025 does not have a statute of limitations on rape. Do you find that to be a problem? And again, I'm looking at it from the perspective of someone who may have to defend someone who is facing allegations 14 years later, 20 years later, when it becomes more difficult to defend yourself against these allegations. Now, here we've got some things to work with, but at the end of the day, how do you feel about that aspect of the law?
Sure. Well, as a citizen, I'm all for it. I feel like if somebody is a real victim of a crime, despite how, especially a vicious crime like a sex crime, they should be able to come forward, and a defendant should be able to be prosecuted accordingly. Now, as a defense attorney, I find some issues with it sometimes, especially if the victim's credibility is really suspect. For example, if there is any type of financial motivation, like what you kind of saw in the Puff Daddy case, that could lead to allegations that the victim is tailoring their testimony for a financial payout. And that's just one example of many I could use. There's also examples where somebody feels jilted, that they were dumped in a certain way and they want to get back at the person, even if it's years later. That can also be an issue. So I think judges need to be really careful with the type of testimony and evidence they allow in, especially when cases are really old.
What a strong case. Just quickly, the fact that they started off at the beginning with the victim testifying strategically, do you think that was a good move in the last 30 seconds or so? Absolutely.
When I was a prosecutor, I always started with the victim, either first or second. Second, if I needed a forensic examiner to testify first to set up the victim. There's an old adage, primacy and recency are the things that jurors remember the most. And, you want to start strong, you want to end strong. So I think that it was a great move.
Yeah, it's a great move. And then you call a mom who supports her story, and that's kind of the way you go along with the case. All right, Josh, stand by. We're going to take a break. But before we do, quick programming note. You can